$852 billion. That is the valuation at stake when Elon Musk filed suit against OpenAI and its CEO Sam Altman in February 2024. Two men, one founding promise: build artificial general intelligence for the benefit of all humanity, not for profit. Then something changed. The non-profit became a capped profit company. The capped profit company attracted billions from Microsoft, and the co-founder who walked away says the mission was quietly buried. How do you take a pledge to save humanity and turn it into the most expensive betrayal lawsuit in the history of technology? The answer starts with a handshake, a charter, and a number that was never supposed to exist. In December 2015, a group of researchers and technologists gathered in San Francisco with a shared conviction. Artificial intelligence was advancing faster than anyone could safely control, and the organizations most likely to build it first were also the ones most incentivized to deploy it recklessly. The solution, they argued, was a non-profit. A laboratory with no shareholders to satisfy, no quarterly earnings to defend, and no pressure to race a competitor to market at the cost of safety. Elon Musk and Sam Altman were the two most prominent names attached to that founding vision. Musk, already the most recognizable entrepreneur on the planet through Tesla and SpaceX, brought credibility and an initial pledge of funding. Altman, then president of Y Combinator and one of Silicon Valley's most connected operators, brought institutional relationships and a talent for building organizations. Together, according to the founding charter and contemporaneous reporting by established media outlets including the New York Times and Wired, they committed OpenAI to a specific legal structure, a Delaware non-profit corporation incorporated in December 2015, whose stated mission was the responsible development and maintenance of advanced AI for the long. The founding documents, which Musk's 2024 lawsuit placed into the public record, described an organization that would publish its research openly, share its work with the scientific community, and explicitly avoid concentrating the power of advanced AI in any single company's hands. The name itself was a statement of intent: open, available. In the first 2 years, OpenAI operated as a research institution rather than a product company. It attracted some of the most respected AI researchers in the world, including Ilya Sutskever, who left Google Brain to become chief scientist. It ran experiments on reinforcement learning, language modeling, and robotic systems. The budget was modest by the standards of what would follow. Musk, according to court filings, contributed or pledged approximately $100 million toward the organization's early funding. Altman became CEO in 2019. That same year, OpenAI announced a structural change that would later become the central exhibit in Musk's lawsuit. The organization created a new entity, OpenAI LP, a capped profit, limited partnership sitting beneath the non-profit parent. The stated justification was pragmatic. Training frontier AI models required the capped profit structure, the organization argued, would allow it to raise investment capital while legally limiting investor returns, preserving the non-profit mission at the top of the corporate hierarchy. Microsoft announced a $1 billion investment in OpenAI LP in July 2019. It was the beginning of a relationship that would ultimately see Microsoft commit, according to its own public filings and established media reporting, a total of approximately $13 billion to OpenAI across multiple tranches. For a time, the structure held its public credibility. GPT-2, GPT-3, DALL-E, Codex. Each release generated global attention and reinforced OpenAI's position as the world's leading AI laboratory. The organization was simultaneously a research institution, a product company, and a symbol of the idea that safety and capability could coexist. The valuation of OpenAI LP climbed. The mission statement remained unchanged on the website. Musk had already departed OpenAI's board in February 2000, AI's board in February 2018, citing a potential conflict of interest with Tesla's own AI development work. That departure, and what the lawsuit Elon Musk filed in the Superior Court of California, County of San Francisco, on February 29, 2024, was not primarily about money. It was about a document. Specifically, a series of internal communications that Musk's legal team argued demonstrated a deliberate decision by OpenAI's leadership to abandon the non-profit mission in favor of building a commercially dominant AI company, with Microsoft as its primary commercial partner and beneficiary. The complaint, which is a matter of public court record, alleged breach of contract, breach of fiduciary duty, and unfair business practices. It named Sam Altman, OpenAI co-founder. The core allegation was this: Musk had been induced to contribute funding and reputation to OpenAI on the basis of specific representations about its non-profit structure and open research mission, and those representations had been abandoned without his knowledge or consent. Here is what no one saw coming when the lawsuit landed. Musk did not merely allege that OpenAI had changed direction. He attached what his filing described as internal emails exchanged between himself, Altman, and Brockman in the years surrounding the 2019 restructuring. Those communications, as quoted in the complaint, showed the three men explicitly discussing the tension between the non-profit model and the capital requirements of frontier AI development. In one exchange cited in the filing, Altman reportedly acknowledged that the original open research model might not be compatible with building the most powerful AI systems. OpenAI's response was swift and pointed. The organization published what it described as a selection of its own contemporaneous emails on its official website in March 2024, arguing that the full context of those communications showed Musk himself had at various points advocated for a for-profit structure, including a proposal attributed to Musk in OpenAI's published materials that he take majority equity control of OpenAI outright. OpenAI further stated that Musk had ceased his funding commitments before the restructuring was completed, and that his departure from the board was the relevant break in the relationship, not any subsequent corporate decision. The competing document dumps created an unusual situation. Two parties in active litigation were each selectively publishing internal communications in an attempt to shape public perception of the case before trial. Legal analysts quoted by established media outlets including Reuters and the Wall Street Journal noted this was highly atypical and suggested both sides believed the court of public opinion mattered as much as the court of law. Musk voluntarily dismissed that first complaint in June 2024, but the case did not end. It accelerated. In August 2024, Musk refiled with a significantly expanded complaint in federal court. The new filing added defendants, added causes of action under the federal RICO statute, the Racketeer, Influenced and Corrupt Organizations Act, and added a damages claim that, when accounting for OpenAI's then current valuation trajectory, pointed toward a figure in the hundreds of billions of dollars. The RICO allegations were the most aggressive element. They alleged, according to the court filing, a coordinated scheme by Altman, Brockman, and Microsoft to defraud Musk and other early donors by inducing charitable contributions under false pretenses. Specifically, the pretense that OpenAI would remain a non-profit pursuing open research, while secretly planning a commercial pivot that would benefit Microsoft's competitive position in the AI market. Microsoft's investment, which gave it exclusive licensing rights to OpenAI's technology and deep integration with its Azure cloud infrastructure, was central to this theory. The complaint argued that the value transferred to Microsoft through that arrangement, access to the most capable AI models in the world at preferential terms, represented an enormous and undisclosed benefit flowing from what had originally been presented as charitable donations. OpenAI's valuation at the time of the refiled complaint stood at approximately $150 billion, according to reporting by established media outlets citing the company's then current fundraising round. By early 2025, that figure had climbed further. The $852 billion number in the case title reflects the aggregated valuation and damages framework as described in analyst coverage and legal commentary on the federal complaint, a figure that made this, by any measure, the largest dispute in the history of the technology industry. In late 2024, OpenAI confirmed it was pursuing a conversion of its capped profit limited partnership into a Delaware public benefit corporation. The non-profit parent, OpenAI Inc., would retain a minority equity stake in the new for-profit entity rather than maintaining its position at the top of the corporate hierarchy. The announcement was framed by OpenAI's leadership as a necessary evolution, a structure that would allow the organization to compete for talent, raise capital at scale, and operate with the governance clarity required of a company that might one day pursue a public offering. For Musk's legal team, the timing was extraordinary. The conversion announcement arrived while the federal RICO lawsuit was in active proceedings. The complaint was immediately amended to incorporate the conversion as direct evidence of the alleged scheme, the argument being that the restructuring confirmed in real time precisely what Musk had alleged, that OpenAI's leadership had always intended to build a commercial AI empire and had used the non-profit structure as a fundraising and credibility vehicle in the interim. But here is the detail that sharpened everything. The conversion plan, as reported by established media outlets including the New York Times and Bloomberg in late 2024 and early 2025, included a provision under which Sam Altman would receive an equity stake in the new for-profit entity. The size of that stake was reported to be in the range of 7%, which, at OpenAI's then current valuation, would represent a personal financial interest worth billions of dollars. Altman had previously stated publicly on multiple occasions that he held no equity in OpenAI. The conversion would change that. OpenAI's position was that the equity grant was appropriate compensation for Altman's role in building one of the most consequential technology companies in history, and that the conversion had been reviewed and approved by the nonprofit board. The California Attorney General's Office, which has regulatory oversight of nonprofit conversions in California, confirmed it was reviewing the transaction. The Delaware Attorney General similarly indicated oversight interest, according to reporting by established media. The nonprofit board's role became a separate thread of scrutiny. In November 2023, before the Musk lawsuit, and in a sequence of events that became part of the broader factual record, the OpenAI board had briefly fired Altman, citing, according to its public statement at the time, a loss of confidence in his candor with the board. Altman was reinstated within 5 days following pressure from employees and investors, including Microsoft. Several board members who had voted to remove him subsequently departed. The episode, documented extensively by established media, including The Atlantic and The Verge, raised questions about the functional independence of the non-profit board that Musk's legal filings would lay. Through the first half of 2025, the federal litigation continued. OpenAI filed motions to dismiss the RICO claims, arguing that the statute was not designed for disputes of this character and that Musk's real grievance was a business disagreement dressed in criminal statutory language. Musk's legal team opposed. The court had not issued a final ruling on the motions to dismiss as of the production date of this documentary, and the case remained active in the Northern District of California. Meanwhile, Musk had founded his own AI company. XAI, incorporated in 2023, raised $6 billion in a Series B funding round. Its flagship product, The Grok language model was integrated into the X platform, formerly Twitter. Musk's critics argued the lawsuit was as much a competitive maneuver as a principled stand. His supporters argued that the documents spoke for themselves. Both things could be true simultaneously, and in the history of financial and corporate litigation, they often are. What was not in dispute was the scale. A laboratory founded on a pledge of open, non-profit AI research had become, within 9 years, a company at the center of the largest corporate litigation in technology history, with a valuation trajectory that made every other tech dispute look like a rounding error. As of the production date of this documentary, the federal lawsuit filed by Elon Musk against OpenAI, Sam Altman, Greg Brockman, and Microsoft remains active in the Northern District of California. No final judgment has been issued. No settlement has been publicly announced. The motions to dismiss filed by OpenAI are pending. The case is proceeding through discovery, the phase in which each side compels the other to produce internal documents, communications, and records under court supervision. Discovery, in a case of this complexity, is itself a form of accountability. Whatever the ultimate legal outcome, the process of compelled disclosure will place into the public record a body of internal communications, board minutes, and financial agreements that would otherwise remain private. That is not a small thing. The history of corporate litigation is full of cases where the trial never concluded, but the documents changed everything. OpenAI's conversion to a public benefit corporation, if completed and approved by the relevant attorneys general, will represent a fundamental transformation of the organization's legal identity. The non-profit parent will hold a minority equity. The new for-profit entity will be answerable to shareholders in ways the original structure explicitly prohibited. Whether that outcome is a pragmatic adaptation to the realities of frontier AI development or a betrayal of the founding mission is a question the court may ultimately answer, or may leave to history. Sam Altman has not been convicted of any crime. He has not been found liable by any court. He has not been sanctioned by any regulator. These are facts, and they matter. The allegations in Musk's complaint are allegations. The RICO claims are contested. The characterization of the 2019 restructuring as fraud is Musk's legal theory, not an established. This documentary reports the case as the record supports it, a live federal dispute between two of the most prominent figures in technology, built on competing interpretations of documents that both sides have now made public. What the record does establish, without dispute, is the sequence. A non-profit was founded with a specific mission. It restructured into a capped profit entity. It raised billions from a single corporate partner. It grew to a valuation that made it one of the most valuable private companies in history. And it is now converting into a structure that its own founders, at least one of them, argue was never the plan. The lesson the record supports is narrow and precise. Legal structures are only as durable as the governance mechanisms designed to enforce them. A non-profit charter, without an independent board empowered to resist commercial pressure, is a statement of intent rather than a constraint. The distance between those two things, a statement of intent and an enforceable constraint, is where this case lives. $852 billion. That is the number attached to a promise made in a San Francisco conference room in December 2015. Whether the promise was broken, and by whom, is now a question for the Northern District of California. The answer, when it comes, will say something important, not just about OpenAI, but about whether the structures we build to contain the most powerful technologies we have ever created are built to last.